All right, good afternoon, everyone. Welcome to our September webinar. Thank you so much for joining us. I'm Ann Badmus, and I'm going to go ahead and share my screen so that we can take a look at the or get started with the webinar. So sorry for the slight delay here, but let me just go ahead and share my screen and get started. So hopefully you all can see my screen. I'm just going to go ahead and get the slideshow started. And as we go along, we'll be admitting new viewers to the room as well. Okay, I think we have everyone here. Okay, well, welcome again to our webinar. And what we're going to talk about this webinar is what's new in employment and business-related immigration. There's a lot going on. There's no way we can cover everything that is happening today. I'm sure many of you over the weekend or so have heard a lot of news, particularly about the H-1B visa announcement. So we're definitely going to spend time with that. I do want to give everyone the opportunity to answer questions. So please go ahead and if you have questions, start putting them into the chat. We will respond to them in the chat, but we'll also respond to them live or out loud, and also have an opportunity for you to ask questions at the end. So we're going to go ahead and get started. Again, please use your chat, but I do want to make sure everyone understands that, or make sure that you, when you ask your questions, try to keep your questions in a general manner. This is a public forum. We want to maintain confidentiality for you. So please do not provide any personal details that could potentially identify you or well, actually identify your situation. So please try to keep your questions very general about the things that we're discussing or other employment or business related immigration news that you might have heard and have questions on as well. So okay, so in addition to that, I do want to let everyone know that what we're providing here in this presentation is general in nature. It's general information. It cannot be really considered advice for your specific situation. So if you see something here that you have concerns about as it relates to you, you should definitely reach out to one of our attorneys and to get more clarification and advice regarding your specific situation. So let's just jump right in and talk about the presidential proclamation or executive order that we heard about and was announced on, I believe it was Friday evening, September 19th, where it was just pretty much a blanket announcement just out there in the news. Even the executive order itself was not very clear, and of course this caused a lot of confusion, had people changing their plans as far as travel is concerned. And so over the past 4 or 5 days or so, there's been some clarification, but by no means is it really absolutely clear how this rule or whether this rule will, or this won't be not a rule, but how this proclamation will actually play out. So again, this is something that's not clear to us, but we're going to try to see and just try to decipher as much as we can from what we know today. It could change tomorrow. So please understand that. And we will try to keep you all updated on our newsletter as well as our blog and our videos as well. So what does the proclamation say? Well, generally it says we're banning the entry of certain H-1B workers unless $100,000 fee is paid for that worker's petition. So what does that mean? Effective September 21st, which was Monday. So that actual fee rule went into place on that day, on September 21st, and it's expected to run if it continues for 12 months, but it could be extended beyond that time frame. So that's number one. So the time frame is effective September 21st. So That being said, it applies only to H-1B workers who are outside the US and attempt to enter the US after September 2025, but it does not apply in those circumstances to people who had their applications either submitted before September 21st, so before this Monday, before Sunday, and those whose petitions are already approved. So if you already have an H-1B petition that was approved, or you've also received an H-1B visa that was issued before that date, then this rule does not apply, that there's no requirement to pay $100,000 fee for your petition, and you're able to come into the country um, uh, if these apply to you. So just to clarify a little bit more, those whose petitions were filed before. So petition is the H-1B petition. This is where the employer has actually submitted the application to classify you as an H-1B employee. So if your petition was filed before September 21st, 2025, and eventually approved, and you travel outside the US and you have you receive an H-1B visa, there's no fee required for you to be able to return back to the US. Of course, if your petition was already approved before, before September 21st, 2025, then of course the same situation applies. If you're outside the US, you have a visa and you're coming in with that visa, there's no $100,000 fee required. And of course, if you've had your visa and your passport, then there's no $100,000 fee. So that's about all we know right now. There's still a lot of questions about that, certainly. One thing I do want to mention, and we'll talk a little bit more about what those questions are, because there's so many different aspects to H-1B petitions, and this announcement by no means, again, was not clear. It does not really specify the exact situations where this fee would apply or what exemptions would be in place, except for the national interest exemption, which basically says that if you can show that there's the U.S. There's a greater interest of the U.S. in your particular employment or your employee's particular employment, that you may be exempted from this fee. Their employer may be exempted from this fee. So what we have heard a little bit that we've heard that potentially those in healthcare could be considered to be national exempt from this if their work would be in the national interest. We don't know if that's going to be a blanket exemption, or it means that each person who is a healthcare worker that's being sponsored, if you can provide an argument that the national interest is served by that person working in the US, then you could be exempt from that fee. But again, right now we're hearing it's just about a case by case basis. So there's nothing that says absolutely anyone who's in a particular industry or particular job, particular circumstance, that those people will be exempted. It's a case by case basis there. Again, if you have questions as these come up, feel free to put them into the chat, so we will be able to answer those questions as well. So as I said, it's very, very unclear as to how this will be implemented. We don't know when the fee would be required. But certainly, the announcement came on the 19th. The government does not have any forms, does not really have any process, as far as we can tell, in terms of how they will collect this fee, when the fee has to be collected. All those things are definitely up in the air. We hope that in the next few hopefully within the next couple of weeks or so, depending on when they're planning to actually require these for new applications, new petitions, that we'll get more information. Also, keep in mind that there more than likely will be lawsuits against this proclamation, because there are questions of whether or not the president or the president's office can even require this type of fee, whether it should actually have gone through Congress to be the legislative body that makes the decision or determines what fees are to be applied, because visas are really under the purview of Congress, not the president. The president will administer those, but by law or by the Constitution, that Congress is the body that should be deciding the path to immigrate to the U.S., including things like H-1B visas. So that's out there as well, and we do expect to see something. Probably we will see some lawsuits being filed and determine what the courts will say about this particular fee requirement. So there's many unanswered questions, such as we understand from what we've heard so far, new fees, new applications will be subject to this fee. However, does that include, well, doesn't it, for renewals it may not apply, but does it apply? We don't actually know. I mean, we're thinking it could be possibly that it's only for the first time, but will it be required for renewals? Will it be required for changes of employer? Because someone who's here on a H-1B decides to change employment or and has the new employer apply, does that fee also apply to that? If you amend the petition, meaning that you make some changes in the jobs, for example, or the location, and you're amending it, will a fee be applied? Another question is, will cap exempt positions or H-1B1 visas have this fee as well? Will extensions of stay, including change of employer, again, for those in H-1B status or those who are currently in H-1B status or change of status, if it was filed after September 21st, will these applications be processed without payment? Again, and also does the fee apply to H-4 dependents? So those are kind of questions out there. Hopefully we will be getting answers on those soon. Let me check if there's a question I'd like to go ahead and try to answer as we go along, so that if we're going to address this certain area, I want to go ahead and talk about that. So I do see a question. So are there any specific exemptions or waivers for healthcare providers? So that's a good question. I did touch on that. And again, right now we don't have a blanket exemption. We have not seen that. There is that national interest exemption, and we've heard that there might be something eventually for exemptions for maybe physicians. We've not heard all healthcare providers, but we don't know that as well. Now, based on what we know today, if we were having to get a waiver today of that fee, that would mean that you would just have to make your case, whether you are a healthcare provider or any other kind of occupation. You can always make your national interest exemption claim. Whether they'll approve it, of course, is going to be on a case-by-case basis, but currently we don't know of any actual exemption for healthcare providers, a blanket exemption. So another question we have regarding this topic is applies to who attempt to. So the question is, the previous page, I think the previous slide says applies to workers who attempt to enter the U.S. So any idea whether or not this applies to workers already in F1 OPT who would apply for the next lottery? So our understanding is that they do expect the fee to apply to the next lottery, but only for those who are being sponsored, who are outside the U.S. and actually have to go to the embassy in order to get their H-1B visa and return in. So if you're doing a change of status from being F1 to H-1B and you're remaining in the U.S., then you should not, then based on what we understand today, it should not require, there should be no fee required. So if your employer in their H-1B petition ticks off change of status, because that's one of the questions on an H-1B petition is, are you asking for a visa to be issued outside at the U.S. Embassy, or what we call consular process? Are you asking for an extension of the current H-1B? Or are you asking for a change of status from one status in the U.S. to another? So our understanding right now is if you're asking for that change of status from F1 or visitor or whatever legal status you're in now to be changed to H-1B, then that fee should not apply. Okay. Any other questions? Again, I want to give time for people to ask about this particular topic since it is of interest. So if there's any other questions? I do see a question here about if the fee is a one-time fee. So our understanding is that it is a one-time fee for the petition. So if you're filing a petition on behalf of an H1, or if employer is filing a petition for an H-1B employee and it's their first petition, and that employee is outside the US, then that there is a one-time fee paid at the time of the petition. Now, if that person is doing a change of status, for example, the fee may not apply at that time, but again, it's not clear, but it could potentially still apply if that individual person got their H-1B, left the US for whatever reason for personal or business reasons, and needed to get an H-1B stamp, then potentially a fee could apply. That fee could be required at that time as well. So it's up in the air, but it is supposed to be at least a one-time fee for that particular employer and employee, as far as we understand. But yes, it is the other question is the fee required to be paid by the employer? And yes, it is required. Like most H-1B fees, the fee would be employer paid, not paid by the employee. Let me see, I have another question here, follow up on the previous question. If we have current employees who have not entered in the H-1B lottery, this fee does not apply if they are already in the US. So I'm not a little unclear about that question, because if I guess maybe so. I think if you're saying if your employee, I'm assuming your employee is probably in a different status working for you, like a F1 OPT, for example. So yes, if they are on F1 OPT, they do get into the lottery. You do apply for them in the lottery, they get accepted, and then you do not, and then you apply for their H-1B. If you are asking for a change of status from F1 to H-1B, then you should not have to pay that fee, at least not at that time when you apply for them, after they win the lottery at that point. Another question is there somewhere in the process 100,000 K fee to getting the F1 in the first place? So for getting an F1, as far as I know, there is no fee involved, because F1 is really the individual student's application. Of course, when they apply for F1, they do have to show that they have the resources for school and that sort of thing, but there's no fee associated with getting F1 status and then getting F1 OPT once you complete your studies and are allowed to have at least 1 year of practical training after school. So that part, I do not know of any fee associated with that. But if you're asking again about F1 changing to H-1B and they remain in the US, then my understanding is there's no fee at that point. Okay. Let's see if there's any other questions. Currently, another question is, our current H-1B and H-4 visa holders, is there any risk of being denied entry with the new rules? So if you're referring to the $100,000 fee, there should not be if your petition if you had already been approved before September 21st, 2025. This is supposed to be applied only to applicants after September 21st, 2025, with certain exceptions. But if you are already approved, you already have H-1B status, that should, before September 21st, 2025, you should not have that issue. Or even if your application was submitted on September 20th, for example, 2025, and it gets approved, this fee should not apply to you as well. Okay. All right, so please feel free, even if we go on to another topic, to go ahead and ask questions about any topic that we're covering, or if you have some other questions related to employment or business immigration. So the next thing is kind of tied to the idea of travel for those people who have H-1B or other types of non-immigrant visas. Non-immigrant visas meaning could be a visitor visa, student visa, it could be an O1, various types of work visas. So the Department of State, which is the agency that controls all of the U.S. embassies outside the United States, they changed a policy, or at least announced a difference in policy on September 6th, where it stated that if you are applying for a visa, let's continue with the H-1B path. So if you're applying for an H-1B visa, for example, you should apply in your home country or the country where you live. So your home country, of course, could be your country of citizenship. If you have multiple citizenships, you can certainly apply in any country where you're a citizen, or if you're living in a country where you're not a citizen, but perhaps you have residence there, legal residence there, you can apply there. Now, the operative word is should. It does not say must, although more than likely you would not be granted an interview in any other country other than your home country or country where you live. But the idea is that you should apply in those countries. And what we understand is that in the cases that in U.S. consular post in Canada, oftentimes people would go to Canada and apply for their visa, even though they were not resident or citizens of Canada, because Canada has had a longstanding policy of accepting what they call third country nationals. People who are not, from Canada could actually apply for their visas there in Canada under certain conditions. So our understanding is that this probably will be phased out, or they no longer will process those types of things. However, it is important to know that if you have applied in a country where you are not you are a third country national and you already have an interview, for example, it does not mean that you cannot be approved simply because you did not apply in your home country or country where you live. Although we are hearing reports that is happening, where the consulates mistakenly are assuming that they cannot issue a visa because they're not the home country or country of residence. But to be safe, it's best to be sure that you apply only in your home countries and do not go anywhere where you would be considered a third country national. So I want to kind of show some other, hopefully we will be able to see this. So if you see my screen here, we should be able to see that under the announcement that happened under the Department of State. So we point out here, adjudicating non-immigrant visa applicants in their country. Let me make sure you're seeing that. Yeah, okay. They are basically saying that certain countries do not have embassies or consulates in those countries. So if you are from one of these countries that are listed on this website, for example, Venezuela, Sudan, Russia, Iran, of course, Haiti, Cuba, about 15 countries are here, so maybe 20 countries. There are designated locations for those in different countries. So you have to be sure that you go to those particular countries. You will not be able to go to any other country unless you have residence in another country. So of course, if you're a citizen of a different country, if you have citizenship in Cuba or Haiti, but you also are a citizen of Canada, then of course you can go to Canada. Or if you're a resident, have a legal residence in Canada or another country, you can certainly go there. But it's important to know if you're going to apply for a visa that you go to the right post there. So let me go back to, oh my goodness, okay. Trying to maneuver this, but okay. So back to this. So this is the change that we're seeing here. We do anticipate a lot more changes in terms of policy. There have already been other changes as far as how quickly visas can be issued at these embassies. Also, what we call drop box, where sometimes you can mail in your visa request, and now it looks like interviews, more and more the interviews are required. So it's important to really check out your U.S. embassy process. You can go online to their websites and determine what their requirements are there as far as whether they have Dropbox or whether you need to appear for an interview, how long the wait times are. There's a lot of variables in that. So be cautious when you're looking at trying to get your visa outside the US. Um, Let me see. I just want to check if there's any other questions that we have. There's some questions that kind of go back to relating to the other to the fee. So does the fee, the 100,000 fee, does the fee apply for change of status to J1 to H1B without leaving the US? So very similarly, as we discussed about the F1 situation of changing to H1B, it applies to any status. It does not apply if you are going from one legal status, whether it's J1, F1, B1, whatever legal status you are in the US to H1B if you are not leaving the US. So if you're doing a change of status from any status, any on the H1B petition, then that fee, based on what we know, should not apply. Another question is if you have an H1B visa previously approved, change back to F1 and then want to go back to H1B, does the fee apply? Would that be considered a new petition even if the visa was approved previously? And that's a very good question. That is one of the unanswered questions that we have. We do not know if that's the case. Certainly, it would probably say that if you are changing, if you are in F1 status and changing back to H1B, then the fee should not apply in that case with respect to the fact that you're asking for a change of status. So as I mentioned before, if you're asking for a change of status, then the fee does not apply. But there could be a fee later if you do leave the US and try to get a visa, even if you had a previous visa approved on your a previous H1B visa approved. That second part of your question is probably where we don't have as much, we don't have really information on how they would treat that. Okay, so next we're just going to go on a little bit more about H1Bs. Part of that proclamation that came out last Friday also talked about trying to make some changes in the way that the H1B prevailing wage determinations are made, or prevailing wage requirements are done. Right now, as has been pretty much forever, H1B does require that the employer agree to pay the minimum of the prevailing wage or actual wage, whichever is higher. What the proclamation that came out Friday is saying is that we don't believe that the wages that that are being used out there are actually the way they should be calculated. So we are asking the Department of Labor to rethink the way that they're determining their wages, the minimum wages, the prevailing wages, and really make higher standards so that we expect that those fees, those wages should be higher than what we're seeing right now. So if that happens, then employers should expect to see that the H1B wage requirements will be higher than what we're seeing or we have seen in the past. We don't know how that calculation will run because right now it's just a directive to the Department of Labor to start a rulemaking process where they're going to, first of all, determine what their methodology would be, put it out there as a rule, and we'll see what responses are there. This could be probably in the next year or so because rulemaking is never really quick. So this is nothing that's happened currently, but this is something that can be anticipated if all goes to plan according to the proclamation. So the other part of that is the idea is that they're looking to with the H1B lottery in particular, they're looking to make some changes in that lottery process and maybe it not be as random as it was before. Instead of being a random lottery, it would be actually more favorable to those who have a higher pay scale. So if you're at the 100,000, 200,000, you're more likely a wage level, you're more likely to get an H1B than someone who is at the 70 or 80 or under 100,000. So a lot of the occupations that qualify for H1B but may not be in fields that are as high paying will have less likelihood of getting an H1B visa. And that kind of relates to what they consider to be skilled workers. So it's not clear what they mean by skilled workers because they're saying skilled workers should be prioritized for these H1B visas, but H1B, and that may be related to being more experienced workers. You might be the way they're looking at it. Again, we won't know until the rules come out. But currently with H1B, you are able to get an H-1B visa by having the minimum of a bachelor's degree. If your position requires, your job requires a bachelor's degree or higher, if you have that bachelor's degree, even without any experience in that field, you're still qualified for an H-1B. But it sounds like the idea is that they're looking for people with higher skill level. Of course, they still have to have the bachelor's degree or equivalent, but those who have a higher skill level with presumably more experience would be prioritized for the H-1B lottery. So this is about the random lottery may be replaced with a more tiered system, qualification system as well. Let me see if we can see if there's any questions related to that. So, okay, some of the questions, I think some people came in a little bit later. I'll go back to you if you're asking about the H-1B fee, because we discussed some of those things already. So we'll come back to that on the question and answer session. So next, I want to discuss the gold card. So I want to discuss that because that also was created by the executive order and also announced on the September 19th as well. So I want to discuss a little bit about what that is. Honestly, I will say I don't think, although, I do not have a crystal ball, under our current legal structure, again, the executive office is not charged with creating paths to visas or paths to actual permanent residence and citizenship. That is under Congress's purview, and Congress is the body that is supposed to determine what ways that someone can get a green card or permanent status or a gold card, all those things. So it really is not something that's supposed to be done by executive order. So we do expect to see some litigation about that as well. And basically pursuing it in the courts to have the courts determine whether the president even has the power to do this kind of thing. But what we know right now is that details are developing. It is a system where at least initially, we heard earlier this year, a claim about a $5 million entry fee, and there is actually another platinum card that's part of that as well. But right now, the gold card is a $1 million to $2 million gift for residency. So this is basically an individual or a company giving the United States free of charge, whatever, except for exchange for the green card or the gold card for residency, giving that gift. There's really no real, as far as we can tell, any other conditions other than, of course, you do need to prove that you don't have any, criminal history, that sort of thing. But if there's no other conditions other than to give that $1 million gift or $2 million gift for residency. Details are developing. So how does that work, or what are the claim features of this gold card? So $1 million individual, again, $2 million for companies. So if you're a company wanting to apply for an employee to get this residence, you would pay or gift the US $2 million. The directive right now to the agencies, the USCIS, to start to try to implement this in 90 days. There is a two-tier process. So what I want to do is just kind of show you, there is a website here. So if we go to the website, let me see if I can get the website up here. Okay, so if we go to the website of the gold card, it actually has the, hopefully everyone can see this, trumpcard.gov. The Trump Gold Card is here. Unlock Life in America. Here's a picture of the actual card, or whatever it is, Trump Gold Card here. And it talks about what the privileges are. So there is the gold card, which is the $1 million to $2 million contribution. The platinum card does have an additional benefit in that if you make a $5 million contribution, You can stay in the US for up to 270 days in the US and not be subject to US tax on non-US income. Currently, anyone who's a permanent resident of the US or a citizen, of course, is subject to taxation on worldwide income. And if you got the Trump Gold Card, then you would be taxed on worldwide income. If you are paying the Trump Platinum Card, then you would not be taxed on worldwide income, even if you were here the majority of your time, 270 days. So if you spent 10 months in the US, I think that's 10 months, something like that, in the US without being subject to that, to US taxes. So that's enough that I'm going to talk about that one, but I just wanted people to see what the proposal is. Again, I do not think that this will go very far, but we never know. So again, some things are not clear. Application forms are not issued. We don't know anything about if there's a limited number. The vetting standards, it's not clear. The source of funds, all these things that typically you might find with like the EB-5 program, which is still in place, where EB-5 has a lot of different requirements there. We don't know how this gold card or platinum card would work as well. So I know it seemed like I'm repeating it, but I do want people to understand that Congress is the legislative, is the body, the governmental body, the branch of the government that's supposed to set visa categories. The Department of Homeland Security can set fees by regulation. So this $100,000 fee that we mentioned, that usually is supposed to go by regulatory process. It should not be that all of a sudden we now have a $100,000 fee without going through the usual rulemaking process. Some of you who have been involved in visa, for having H-1B visa for some time, may know that fees do increase. They've increased H-1B fees and other fees, but usually that goes through a process. It's announced well in advance. It's pretty well managed so that a set time when you can expect those fees to happen, that fee increase to happen. There's also time for the public to comment. We did that. That happened about 2 years ago, where there was a significant increase in a lot of fees, and the public was allowed to comment on that. And then, of course, the government, after a certain period of time, made the fees effective. So that's the usual process. It's usually not a process where a president announced a $100,000 fee and the next day you start paying this fee. So that's one of the reasons why you probably see lawsuits about this as well. With respect to things like the gold card, your executive order cannot create a new visa class, which is basically what this gold card and platinum card is doing. So when you're hearing about things like this is by no means done. We don't know. We'll probably be months and months, maybe even a year or more before we know exactly how this will work, or whether it'll work at all. Let me go back to questions, just so I'll make sure that we're covering anything that's related to some of the information that we just covered. Okay, we'll come back to some of those. Okay, so before we go to question and answer, I just want to now just kind of discuss the October 2025 visa bulletin, particularly as it relates to employment-based visas or green cards. So many of you who are already in the green card process probably know that there's a limited number of green cards available each year. It's 140,000 immigrant visas, which is the same as a green card, that are available in the employment category. So our new October of each year starts the new year where new visas are available, immigrant visas are available. So coming up next week, we will start the new fiscal year and there will be 140,000 new immigrant visas available. So the visa bulletin did just come out, and there was some confusion, or at least we got some feedback of confusion about the visa bulletin. So I want to just go over exactly go over the visa bulletin itself, and so people can understand what is happening now with respect to the availability of green cards in that category. So let me see. I'm sorry, just trying to make sure I'm sharing the right screens. Okay. So if we go to the visa bulletin, uh, okay. So the October visa bulletin shows that, again, it addresses family and employment-based. So we'll go down to the employment-based category. So we have two charts that we look at, the final action chart and the dates for filing chart. And so it's important to know when those charts are relevant to your case. So relevant to all cases at any time is the final action dates, the final action chart. So final action means kind of what it says. It means this is when the government can take final action on your green card application. So if you are in the second stage of the green card process or the last stage of the green card process where either you are waiting outside the US to get your green card or you're in the US and have applied for adjustment of status, you have to look at this chart to see whether or not the government can take final action and approve you for the green card. So if you're already in process, you've gone through you're in adjustment of status, for example, then you have to look at the final action chart to determine whether or not you are now eligible to be finally approved, assuming everything else has been done as far as background checks and medical exams and all of that. So what you look at, of course, is your employment-based category. So you have to know whether you're an EB1, 2, 3, any of these categories. And then, of course, you look at where your country of birth. So if you were born in any other country other than China, India, Mexico, or Philippines, you'd look at this all chargeability areas, or what we call the rest of the world. And then, of course, if you're born in any of the other countries, you look at those columns. So let's just go with the EB2, all chargeability. So if you're in the EB2 category and you filed your PERM or your I-140 application before December 1st, 2023, and you have your adjustment application filed, then you are now able to actually be approved for the green card. Now, there is the dates for filing chart. So the dates for filing is, again, kind of what it says is that this determines the month that you can file adjustment of status. Adjustment of status is going from whatever legal status you're in now to actually getting the green card. So that I-485 adjustment of status must be applied for in order for you to get your green card. So a lot of people are in line in queue waiting to apply for their adjustment of status. So this chart, if the USCIS uses this chart, is what you would go by. USCIS can determine every year as far as every month as far as adjustment of status is concerned, which chart they would use in order to allow people to apply adjustment of status. Usually in October, they do allow for dates for filing, and that usually is a better chart. So we are now seeing that the USCIS has agreed to use this dates for filing chart. So a lot of people who have been waiting to file their adjustment of status, if their priority date is before July 15th, 2024. If you're from the rest of the world, for China, it's December 1st, 2021, India, December 1st, 2013, and so on. So if your priority date is before that date, then you are able to file. So this has opened up a lot of ability. This has given a lot of people the ability to file because they've been waiting for at least a year or two to be able to file their adjustment status. So this has been quite a bit of progress in that. However, this does not have anything to do with the approvability or when you can be approved. You can file, but if your file the adjustment of status, if your priority date is before the cutoff dates here. But if your as I scroll up, if your priority date is later than these cutoff dates, you still will not be approved until your priority date is before the cutoff date on the final action chart. So it's important to know that you could still be waiting another year or two, depending on how these charts move, before you actually get your green card, regardless of whether all of the processing has been done. Okay. So I think we'll go back to questions and see if anyone has any questions here. And before we go with questions, I just want everybody to know again, this information is general in nature. So let's just go on and see what we have in terms of any questions. I see a few questions. I know there were some answers in chat, but we will go ahead and still answer them so that everyone can hear or know the responses there. So the ones I had not already previously answered. So I believe someone asked, I think this is a newer question, if you have an approved H-1B petition before September 1st, while in the US and travel to the home country for stamping, does this fee apply? No, it does not apply according to our previous discussion and understanding from what we see from the current updates on this. If you had your petition filed or approved before September 21st, then you would not be subject to this fee, or your application would not be subject to this fee even if you traveled for visa stamping. Another question, any communication regarding physicians being exempt? Probably we did discuss this earlier and probably may not have heard it earlier, but basically physicians being exempt, there is no communication. There's rumors to that effect, but no communication to that. So we don't know that as of this time. And keep in mind, we don't know much of anything regarding this fee at this time. There's just really is not enough information. As I mentioned a few minutes ago, the usual process for these things is to go through a rulemaking process where people have a little more notice and are able to actually comment and give feedback on the fees. And then for the government itself, the US Department of Homeland Security or the USCIS, to have time to go through and develop how they will charge any fee and what forms they will need and all those things. So this was very haphazardly done. I will say poorly done, okay, as far as actually, talking about this fee or having people having an understanding, and not just poorly done, but just really outside of the legal process that it should go through. So there's another question, as an undergraduate student, what other routes can be taken other than H-1B? That is very much a specific question related to your background. There are many types of visas, but whether you are qualified for them is really something that you would need to speak with one of our attorneys so that we can understand your full background and see what other options you might have depending on your background. If an employee is entered in the lottery after September 21st, and this is another question, I'm sorry, if an employee is entered in the lottery after September 21st and receives their H-1B, will the fee apply for reentry once they return to get their visa stamp? If you're entered the lottery after September 21st, according to what we know right now, you probably, your petition could be subject to the fee. Especially if you are outside the US. If you're in the US and you go to for a change of status, your petition should not be subject to the fee. However, if you do go home or to your home country to get a visa stamp, then it may be subject to the fee. So again, this is all up in the air. We don't have any specifics, but from what we know, this is probably the case, but it could change. Let's see, if the another question is, if the H-1B is issued after September 1st and the person is traveling to the home country for the stamp, then the fee applies. If you recall, if your application was submitted before September 21st, then the rule does not apply. So regardless of when they approve your H-1B, if your application or your petition, your employer submitted the petition before September 1st, then the fee does not apply. Does the proclamation, another question we have is, does the proclamation apply to concurrent H-1B petition after September 1st? We do not know that yet. Honestly, we don't know. And that's probably the best answer we can give you at this point. Do you anticipate when more information will be given to provide clarity? Unfortunately, we don't know that as well. We wish we could, get something sooner, or again, we wish we could have gone through the typical regular process so that people would have more clarity. But it looks like the government hasn't even figured it out themselves. And so I really don't know when that will happen. Let's see, I see another question. If my H-1B was approved in 2023, do I need to do a H-1B transfer that involves a consular review and visa stamping, would that trigger the fee? It's possible. That is one of the questions we don't know. If it's a change of employer, will this fee apply? Does it, because it says new petitions, but new petition under the legal sense could be someone who's totally new and only going to never had an H-1B, or it could be just simply meaning anytime you file an H-1B petition, whether it's to do a transfer, change of employer, it could apply. So honestly, I would have to say we just don't know yet. Any other questions? We are getting here. Okay. Does the fee apply for renewals and amendments? Again, that we don't know as well. That was one of the slides that we have that we do. Those are questions that are still outstanding. Again, no real guidance on this other than news reports, and a couple of times the government, actually the USCIS has not even really put out anything that's definitive as to how they would approach this whole fee concept. And that is the agency that's supposed to do that. And the embassies, the Department of State, which is the visa processing agency, has not put out anything as well that really is clear about this. Let's see if there's any other questions. Okay. Yeah, and keep, there, we have probably more questions than I could answer as well, because of the lack of information. So I definitely suggest that everyone, follow us in terms of we follow us on YouTube, follow us on, I'm sorry, Facebook, as well as follow us on our blog, on our website, as we try to update these things as they go along. If there's really breaking news, we will also send out to our newsletter as well. So please check back for that. I think we still have time for another question. So let me just go back to that. Will Go Card affect EB1 or EB2? Well, the Go Card is a different category of residence eligibility. So it has nothing to do with any other path to the green card. It's just another path to permanent residence. It is Gold Card or Platinum Card is supposedly another path to permanent status. But it's not no impact on any other way to go down that path. So if you're qualified for EB2, go that route. EB1 as well. But like I said, we really don't have much news or information on the Gold Card itself, or whether or not it will even be a way to get your permanent residence, depending on what the courts say about it. All right. You're welcome. Thank you. All right. Well, thank you all. Again, thank you for joining us. Please do reach out. We will have this recorded on our YouTube page as well. So we wish you all a great afternoon, and check back with us next month for our next webinar. Have a great day.